Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Have you got your tickets to the Federal Bar Association's Immigration Conference in Arlington, Virginia for later this week? I'll be there because it's an awesome conference. But more importantly, a whole bunch of immigration judges, BIA members and attorneys, federal judges, DHS attorneys, U.S.CIS adjudicators, and oil litigators will all be there too. Meet with them, greet with them, fight with them. Do whatever you can get away with under the rules of ethics. Hope to see you there. 8 non-citizen losses for you all to consider this week. Brutal and complicated. Let's do it. First up is matter of Cancinos-Mancio, published by the BIA. With all losses for non-citizens this week, might as well start off with the BIA. This case is about how to apply the modified categorical approach. I caveat that from the onset to note that immigration judges and the BIA must apply the modified categorical approach in the manner ordered by their governing Circuit Court of Appeals. But to the extent that the issue here is unaddressed in a circuit, this decision governs. And it's a pretty straightforward holding. Quote, under the modified categorical approach, an immigration judge may consider the transcript of a plea colloquy in determining the factual basis of a plea, end quote. Fair enough, and to be honest, I thought that was the rule in quite a few circuits already. But let's step back. Mr. Cancinos-Mancio is a lawful permanent resident from Guatemala. But in 2013, quote, he was convicted of aggravated assault pursuant to sections 13-1203 and 13-1204A2 of the Arizona Revised Statutes, end quote, and he received a 3.5-year prison sentence. If that conviction is an aggravated felony crime of violence under I&A section 101A43F, he loses his green card. And IJ said that it was by applying the modified categorical approach. And in this decision, the BIA said that was okay. Arizona Revised Statute section 13-1203A has 3 subsections, and each criminalize a different type of assault. The Ninth Circuit, where these proceedings originate, has held that at least one of the 3 ways doesn't match the definition of a crime of violence, meaning that Arizona Revised Statute annotated 13-1203A generally is not an aggravated felony. But it appears that Mr. Cancinos-Mancio was actually convicted of subsection 2 of that statute. And apparently the Ninth Circuit held in the 2014 decision United States v. Caldera-Torres that a subsection 2 offense meets the definition of a crime of violence. And true, subsection 2 criminalizes, quote, intentionally placing another person in reasonable apprehension of imminent physical injury, end quote. Here's the thing, though. Under the categorical approach, it doesn't matter what subsection Mr. Cancinos-Mancio was convicted of if the statute isn't divisible. That is, if those three subsections are means rather than separate elements of the crime. If, for example, a prosecutor in Arizona can get a conviction simply by showing that someone did any of the three types of assault without having to prove which one, the crime is indivisible. And Mr. Cancinos-Mancio is not removable, regardless of whether the prosecution in his specific case listed a subsection. Problem for Mr. Cancinos-Mancio is that, quote, Arizona state courts have explicitly found that the three subsections listed under Section 13-1203A are separate offenses, end quote. Okay, so the statute is divisible, and that means that the IJ and the BIA can look to a limited class of conviction documents to see which subsection Mr. Cancinos-Mancio was convicted of. And while I started off the case by saying that it was a subsection 2 crime, which again is a crime of violence, I guess it wasn't so clear, because that's what this decision is about. Looking to the transcript of the change of plea hearing, the IJ determined that Mr. Cancinos-Mancio was ultimately convicted of subsection 2. But I guess that's the only record evidence for which subsection he was convicted of. And as DHS has the burden on removability, well, if the IJ erred in reviewing that transcript and can't rely on such documents, then DHS can't meet its removability burden here. But the IJ did not so err, said the BIA. Now true, the plea transcript doesn't actually say, quote, subsection 2, end quote. However, all elements admitted to by Mr. Cancinos-Mancio through his attorney and individually match subsection 2 and only subsection 2. That was sufficient to the BIA, because after all, the Supreme Court itself has said that judges can consider transcripts of plea colloquy at the modified categorical stage to determine the subsection of conviction. Nothing crazy there. But, Mr. Cancinos-Mancio argued, in the Ninth Circuit, it seems, a court can't rely on facts admitted to by an attorney in a plea colloquy if the defendant doesn't himself also admit those facts. That appears to be the holding of the 2015 decision, United States v. Marcia Acosta. Good find, counsel. And maybe so, said the BIA. But in this case, Mr. Cancinos-Mancio did admit to the facts. Here he, quote, specifically assented to the underlying factual basis and admitted to the elements of the offense, end quote. So the IJ properly relied on those facts admitted to in the plea colloquy and determined that they only match a subsection 2 offense. But really then, this is a bit more of a nuanced holding than the case header would indicate, right? It's in fact even more nuanced, because actually, this might only all be okay because the facts that Mr. Cancinos-Mancio ultimately agreed to in the plea colloquy, you know, those facts that only narrowed his conviction to a subsection 2 offense? Well, they were originally also alleged in count 1 of the complaint. Had a count in the complaint not also matched a subsection 2 offense, it seems that no matter what Mr. Cancinos-Mancio had agreed to at the plea colloquy, it might not have mattered. A bit of an open issue there, if you ask me. At least in the Ninth Circuit, where, quote, if the operative charging document limits the charge to a statutory alternative that meets the generic offense definition, a factual basis statement at the plea colloquy and the charge together can establish the crime of conviction because that fact then does become essential, end quote. Emphasis by the Ninth Circuit. So I guess the real holding is here, and at least in the Ninth Circuit, if the non-citizen admits to the facts of a specific subsection at the plea colloquy, and those specific facts are charged in the count that he's pleading to, then removability can be established by relying on a plea colloquy, even if the actual subsection isn't charged. Why such an expansive header, BIA, when the holding itself is clearly narrow? Looking forward to speaking about that with anyone who will listen at the wonderful FBA Immigration Conference in Arlington next week. And that is matter of Cancinos-Mancio. That got a bit heady, huh? Next is Cortez-Amador v. Attorney General of the United States, published by the Third Circuit on April 25th, 2023. This is another Patel-type case, sigh. Also, this case is about Special Immigrant Juvenile Status, or SIJS. Mr. Cortez-Amador fled to the United States from Guatemala at 16 years old after gangs murdered his father. An unaccompanied minor, U.S.C. deemed him abandoned by his parents and therefore granted him Special Immigrant Juvenile Status, a very favorable status that put him on a path to a green card, notwithstanding his illegal entry into the United States. And the fact that he didn't have a qualifying relative. Quote, non-citizen children may receive SIJS only after satisfying a set of rigorous congressionally defined eligibility criteria, including that a juvenile court has found it would not be in the child's best interest to return to their country of last habitual residence, and that the child is dependent on the court or placed in the custody of the state or someone appointed by the state, end quote. A few additional requirements, too. But in what may arguably be the most frustrating thing to happen in all of immigration, Mr. Cortez-Amador then got into criminal trouble after getting SIJS, but before adjusting to lawful permanent residence status. In particular, he was charged in New Jersey with sexual assault on a child under the age of 13 and child endangerment. Ultimately, he pled guilty to giving a child a cigarette and nothing sexual. He received a sentence of less than a year, making it a misdemeanor. But having still not adjusted, he was technically removable for having entered the U.S. as a child unlawfully without inspection or admission. DHS initiated removal proceedings, charging him as such. An IJ found him removable, held that simple SIJS doesn't prevent removal, denied adjustment of status as a matter of discretion based pretty much on the criminal stuff, denied asylum and related relief, and ordered Mr. Cortez-Amador removed. The whole book. The BIA affirmed. Before the Third Circuit, Mr. Cortez-Amador primarily challenged the SIJS holding and adjustment of status stuff. He did not succeed on either challenge. First, the Third Circuit agreed that merely having SIJS alone and without adjustment of status does not prevent removal under INA Section 212A6AI for being present in the U.S. without admission or parole. SIJS is not an admission or parole, said the court. Now true, the special SIJS adjustment provision at INA Section 245H has language that seems to indicate that SIJS status is itself a parole. But read in context of the INA, the court explained that Section 245H is merely explaining that SIJS will equate to an admission or parole for adjustment of status purposes. That is, SIJS can be used by non-citizens who are not formally inspected and admitted or paroled to nevertheless adjust to LPR status, unlike nearly all other non-citizens trying to adjust in the U.S. But that doesn't mean, said the court, that SIJS standing alone is an admission or parole that can prevent removal. It only fills in for one during the adjustment process. That means that Mr. Cortez-Amador is indeed removable. But should the agency nevertheless have granted him adjustment of status based on his receipt of SIJS? Well, the Third Circuit believed that Mr. Cortez-Amador was arguing that the IJ and the BIA improperly weighed positive and negative factors in the discretionary analysis, and to the court, that's precisely the type of factual analysis now barred from review before the circuits and INA Section 242A2. And alright, fine, this might have been the case in the Third Circuit even before Patel. That means that the court can't review the BIA's denial. Concluding then with the denial of asylum and withholding of removal, the Third Circuit saw no error. Although Mr. Cortez-Amador was himself threatened with death in Guatemala by two men, and while those two men did in fact kill his cousin and his father, Mr. Cortez-Amador was not killed or threatened during the 5 months before he fled to the United States. Mr. Cortez-Amador managed to remain alive from the age of 9 to 16, even after his father was killed and before he fled, reasoned the court. Plus, his siblings still live in Guatemala. So, the Third Circuit affirmed the agency's denials. And that is Cortez-Amador, the Attorney General of the U.S. Next is Reese v. Garland, published by the Fifth Circuit on April 24th, 2023. This case is about visa fraud and waivers. And the case actually regards Miss Reese and Mr. Sam Fear. They're both petitioners in this case. The petitioners are from Cambodia, and it appears are a couple. Both of them, however, entered the U.S. on visitor visas, quote, entered into fraudulent marriages with U.S. citizens, and resided together as common-law spouses in the United States, end quote. They got caught and convicted of several crimes arising from the fraudulent marriages, including fraud and misuse of a visa, permits, and other documents, in violation of 18 U.S.C. Section 1546A. Of importance here, in immigration court, both applied for INA Section 237A1H waivers. That statute allows, under certain circumstances, individuals who have obtained LPR status through fraud to waive that fraud and keep their green cards, provided that they have qualifying U.S. citizen or LPR relatives in the U.S. and were otherwise admissible for a green card absent the fraud. Technically, the statute waives a removability allegation under INA Section 237A1A that the individual was inadmissible at the time of admission under INA Section 212A6CI. It's only going to get more complicated from here, folks. Or, as the Fifth Circuit and the Ninth Circuit have put it, a Section 237A1H waiver, quote, transforms an individual who enters the United States with an invalid immigrant visa to the status of one who enters as a non-preference immigrant, despite the fact that a valid immigrant visa would never have been available to the individual at the time of entry, end quote. If the non-citizen qualifies, it's a very favorable waiver. But the IJ summarily denied the waivers here, finding that the petitioners were not otherwise admissible. The reason was because even if they wiped away the fraud, their convictions themselves were crimes involving moral turpitude. Indeed, the BIA recently said so in matter of Nemes and matter of Al-Sabsabi, episodes 46 and 49. Now, we can all agree that Section 237A1H waivers waive removability under Section 237A1A when tethered to a Section 212A6CI inadmissibility allegation. That is, again, Section 237A1H will waive a removability allegation that a non-citizen was inadmissible at the time of admission due to fraud. We all agree. Tell me we agree. But then at the end of Section 237A1H, the statute also reads, quote, a waiver of removal for fraud or misrepresentation granted under this subparagraph shall also operate to waive removal based on the grounds of inadmissibility directly resulting from such fraud or misrepresentation, end quote. What does that mean? Well, the argument goes that an IJ can grant a Section 237A1H waiver and waive all removability of a non-citizen tethered to that fraud. So here, for example, the argument was that an IJ could waive additional removability or inadmissibility based on the fact that the fraud led to criminal convictions, which are CIMTs. A CIMT committed within 5 years of receiving LPR status is another way to remove an LPR. But if the Fifth Circuit adopted the petitioner's arguments here, a Section 237A1H waiver could waive that removability too, if those convictions, of course, were based on the same immigration fraud that is generally waived by a Section 237A1H waiver. Or alternatively, the argument here. In addition to being a CIMT, Section 1546 convictions are actually a listed ground of removability under the rarely discussed provision at INA Section 237A3B III. But again, argued the petitioners, if the basis for those Section 1546 convictions is a fraud that is itself waivable by Section 237A1H, shouldn't that then waive the Section 237A3B III removability as well? The IJ rejected this argument, as did the BIA. Those many minutes of me explaining it are complicated and were difficult to explain, which may be why the Fifth Circuit rejected the argument too, as have apparently 5 other circuits. Explained to the Fifth Circuit by its plain text, Section 237A1H waivers only waive inadmissibility at the time of admission under Section 212A6CI. No other inadmissibility provisions and no other Section 237 removability provisions are covered by the waiver. In any event, Section 237A1H clearly only waives fraud or misrepresentation inadmissibility. The petitioners here, in contrast, are trying to get a conviction-based removability ground waived as well. Can't do that. And it didn't matter to the court that it's all part of the same fraud facts. The statutes of removability and admissibility are different. In an effort to win, very smart counsel argued that the, quote, Supreme Court's reasoning in Judelang v. Holder supports their argument that the BIA's policy is arbitrary and capricious, because the agency hinges a deportable non-citizen's eligibility for discretionary relief on the chance correspondence between statutory categories, end quote. And this case has been complicated enough, so I'm not going to go down the rabbit hole of former Section 212C relief or Judelang v. Holder. But suffice it to say, it's a good argument. The Fifth Circuit, though, was having none of it. Here, and unlike with former Section 212C, the statute and removability frameworks are clear, and the government was simply applying that framework. So to be clear, quote, we hold that Section 237A1H does not function to waive a charge under Section 237A3B III, end quote, or seemingly any other removability provision. Summarily rejecting a multitude of alternative arguments, the Fifth Circuit upheld the removal orders. So yeah, complicated stuff. Here's a more direct quote for your briefs. Remember this for your waiver briefs of all sorts. Congress enacted these waivers because it believed it, quote, more important to unite families and preserve family ties than to enforce strictly the quota limitations or even the many restrictive sections that are designed to keep undesirable or harmful non-citizens out of the country, end quote. Quoting the Supreme Court from 1966, by the way. Also, just to note, it appears that the petitioners were only conditional LPRs. I could be wrong, but if I'm right, it seems that the whole issue might have run into Matter of Bador, published by the BIA in 2022, episode 128. That is, that CLPRs must remove their conditional status before applying for a Section 237A1H waiver, an almost impossible thing to do because removing the conditions of CLPR status requires a showing that the first marriage was bona fide. But why bring up other reasons to deny, Kevin? Good question. And I don't believe Bador had been issued anyway at the time of these removal proceedings below. And that is Reese v. Garland. Moving on to Caldera-Torres v. Garland, published by the 7th Circuit on April 27, 2023. This case is about crimes of domestic violence. Mr. Caldera-Torres is from Mexico, has been living in the United States a long time, and hopes to obtain non-LPR cancellation of removal in his removal proceedings. But many things can bar a non-citizen from even applying, including having been convicted of a crime of domestic violence, as defined in I&A Section 237A2E(I). Mr. Caldera-Torres has a conviction for battery in violation of Wisconsin Statute Section 940.19(1), apparently, quote, arising from an attack on the mother of his daughter, end quote. An IJ and then the BIA determined that the conviction was indeed a crime of domestic violence, and so it precluded Mr. Caldera-Torres from non-LPR cancellation of removal. Here, the 7th Circuit affirmed. To be a crime of domestic violence, the state conviction must first satisfy the elements of a crime of violence as defined at 18 U.S.C. Section 16A. When Justice Barrett sat on the 7th Circuit, she said that this Wisconsin assault statute satisfies those elements, and Beltran-Aguilar v. Whitaker. And Mr. Caldera-Torres obviously can't challenge that then, unless perhaps Bourdain changed the calculus? Unaddressed and seemingly unargued here. So no, Mr. Caldera-Torres argued that under the categorical approach, the victim's identity isn't an element of the Wisconsin assault statute. And so, even if his crime involved domestic violence type facts, the crime can't be an immigration or removal crime of domestic violence because to obtain conviction, the prosecution didn't need to prove a domestic component. And that would be true if the categorical approach applied to the crime of domestic violence analysis at I&A Section 237A2EI. But it does not. Yes, the categorical approach governs whether the elements of the offense satisfy the crime of violence definition at 18 U.S.C. Section 16A. But if it does, whether the crime was domestic in nature permits application of the circumstance-specific approach. So held the Seventh Circuit. The domestic, quote, ingredient need not be part of the crime's elements. It is enough that the victim's status as a protected person be established, end quote. According to the court, quote, all other circuits that have addressed the operation of Section 237A2EI recently have held that the victim's status as a protected person need not be an element of the crime of conviction, end quote. The Seventh Circuit now joins those circuits. Although admittingly, it seems that things are a bit murky in the Ninth Circuit. Anyway, therefore, able to look at the conviction documents to ascertain the identity of the victim, the Seventh Circuit and all courts below properly saw that the victim was the mother of Mr. Caldera-Torres' child. There are many types of protected persons listed at the crime of domestic violence INA statute, including, quote, an individual with whom the person shares a child in common, end quote. So that's satisfied here. It didn't matter to the Seventh Circuit that Mr. Caldera-Torres did not receive a, quote, domestic abuse surcharge, end quote, during the criminal proceedings, which apparently is a special Wisconsin designation that would have lengthened his criminal sentence. To the Seventh Circuit, the record was at best ambiguous, which cut against Mr. Caldera-Torres, because all of this was getting adjudicated in the relief context, and after the Supreme Court's Pereida decision, the burden of persuasion to explain the factual basis for his conviction was on Mr. Caldera-Torres because this was all occurring in the relief context. So, the Seventh Circuit held that the agency properly concluded that Mr. Caldera-Torres was convicted of a crime of domestic violence and therefore barred from non-LPR cancellation of removal. Query this. If a crime of domestic violence must first be a crime of violence, and if aggravated felonies preclude non-LPR cancellation of removal too, then why have this discussion at all? Why not just end it with the fact that the Wisconsin crime here matches the definition of a crime of violence at 18 U.S.C. Section 16A? Well, dear friends, that is because to be an aggravated felony, a crime of violence must also include a sentence to a term of imprisonment of at least 1 year. And I'll bet you Mr. Caldera-Torres didn't receive one. The crime of domestic violence removability provision, in contrast, doesn't have a term of imprisonment requirement. So there you go. And that is Caldera-Torres v. Garland. Sticking with crimes. Next is Somers v. U.S.A., published by the 11th Circuit on April 25, 2023. Patel isn't the only recent Supreme Court decision that's blown up immigration precedent. The court's Bourdain decision from episode 59 that I just mentioned briefly did as well. That's the case redefining the definition of a crime of violence for both sentence enhancement and immigration purposes, and which held essentially that state crimes that permit conviction with a mental state of recklessness cannot be crimes of violence. Paraphrasing, of course. This in turn has led the circuits to reevaluate lots of crimes that had previously been deemed crimes of violence or violent felonies to see if they still are crimes of violence or violent felonies in the sentence enhancement context. And that's what we have here. Is Florida aggravated assault with a deadly weapon in violation of Florida Statute Section 784.021 still a violent felony under the Armed Career Criminal Act? If it is, Mr. Somers' federal criminal sentence remains enhanced, and this Florida assault statute is still an aggravated felony crime of violence under INA Section 11843F. So is it still, after Bourdain? It is, said the 11th Circuit. And really, this seems to be a bit inevitable based on the Florida Supreme Court having answered the very question on certification from the 11th Circuit in this very case last year. In the Florida Supreme Court's Somers decision, the Florida Supreme Court resolved a lower Florida court circuit split to hold that Florida's generic assault statute, Florida Statute 784.0111, quote, demands the specific intent to direct a threat at another person and therefore cannot be violated by a reckless act, end quote. Circuits like the 11th Circuit owe complete deference to a state Supreme Court's explanation of the elements of a state criminal offense. no questions asked. So the Florida Supreme Court's Somers decision totally governs. Quote, the Florida Supreme Court's interpretation of Florida law is determinative here, end quote. And that pretty much destroys Mr. Somers' argument in the sentence enhancement context. His crime definitely has the usual elements required of violent felonies and crimes of violence. It's an aggravated assault statute and it requires use of a deadly weapon. And now, the Florida Supreme Court has held that all assaults in Florida, it seems, require as an element a mens rea sufficient to make them violent. It seems that they can't be committed recklessly, as Bourdain explains, would have made them insufficiently violent. And so, to be exceptionally clear, all you Florida attorneys, it would appear that based on what the Florida Supreme Court said in 2022, that all assaults in Florida, no matter how simple, pass the Bourdain mens rea test and entail a sufficient mental state to make them crimes of violence, provided that the risk of force is violent enough. That doesn't mean that all Florida assault crimes are necessarily crimes of violence, but to me, it sure means that Bourdain didn't change anything with Florida assault crimes. So it appears what was good pre-Bourdain likely remains good law post-Bourdain in Florida. And to the extent there was pre-Somers case law relying on a belief that Florida assault could be committed recklessly, be it in the aggravated felony or CIMT context, well, it's out the window, because the Florida Supreme Court has explained that that analysis was wrong. But keep an eye on state Supreme Court crimmigration decisions if you have the bandwidth, counsels. Quote, when the Florida Supreme Court interprets a statute, it tells us what that statute always meant, end quote. So to me, that would mean, for example, that had the Florida Supreme Court said that aggravated assault can be committed recklessly, all prior removal orders premised on a finding that Florida aggravated assault was a crime of violence would have had to have been reopened, because they would have been wrong from the start. It wouldn't be a change in law. It would be what in actuality had always been. Keep it in mind. And that is Somers v. USA. More cases after a short break. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey, and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. This podcast is also sponsored by Capital Good Fund. Millions of families seeking to improve their immigration status face financial barriers due to the high cost of legal services. Nonprofit Capital Good Fund is working to make these resources available to all, especially those who would otherwise not qualify for traditional loans. Certified CDFI Capital Good Fund is partnering with attorneys to provide the financial services families need. They offer affordable financing with no closing fee or down payments for those working with attorneys to move their case forward and get attorneys out of the accounts receivable business. To learn more about the program, email immigration@goodfund.us or call 866-584-3651. And tell them who sent you. Next is Care v. Garland, published by the 4th Circuit on April 24th, 2023. Done with the crimes and on to the cat. This case is about torture. Mr. Care is from Jamaica. 33 years ago, at 10 years old, he was brought to the U.S. to live as an LPR with his father. In what can only be thought of as a tragic failing all around, Mr. Care's father, quote, unfortunately, was a high-ranking member of a notorious transnational Jamaican gang known as the Shower Posse, and Mr. Care developed a close relationship with many of his father's fellow gang members. Mr. Care joined the Shower Posse when he was in his late teens, and by the early 2000s, he was trafficking cocaine on behalf of the gang, End quote. What does the U.S. owe LPR children like Mr. Kerr? According to Mr. Kerr, he was soon himself targeted by shower posse members for two reasons. First, in 2003 or 2004, he began a same-sex relationship with a man. Quote, the shower posse was aggressively homophobic, viewing the prospect of a gay gang member as a stain on their reputation, end quote, and when they found out, they threatened and denigrated Mr. Kerr. Second, and perhaps a bit less sympathetic, Mr. Kerr believed he wasn't getting a large enough cut for his drug trafficking for the gang, and so he began to steal drugs from the shower posse and sell them on his own. This led the shower posse to attempt to murder Mr. Kerr on multiple occasions, all in the United States. Mr. Kerr stopped his relationship and left the posse in fear for his life in 2009. He moved and he changed his name. By this point, though, he already had a very bad criminal record. Perhaps if his dad hadn't been a gang leader, Mr. Kerr would have naturalized well before becoming an adult gang member. But Mr. Kerr never became a U.S. citizen, which therefore allowed DHS to place him in removal proceedings in 2020. Deemed removable with a serious criminal record, Mr. Kerr applied for only deferral of removal under the Convention Against Torture, the only thing he was likely eligible for anyway. Mr. Kerr claimed that he would be tortured and killed if returned to Jamaica, primarily because of his affiliation and disputes with the shower posse and his sexual orientation. He submitted an expert report and country condition evidence. He feared four actors in particular, quote, the shower posse gang, other gangs in Jamaica, Jamaican authorities, and Jamaican civilians, end quote. This was mainly because of his past affiliation with the shower posse and his status as a, quote, bi-curious man, end quote. Cat protection requires a showing that there exists at least a 51% chance that a non-citizen will be tortured, and in the Fourth Circuit, as with most circuits, immigration judges must aggregate the risk of all tortures. More on that in a minute. The IJ here deemed it all insufficient. In what smells a bit like an attorney advisor-assisted decision, the IJ denied everything thoroughly. The biggest problem, reasoned the IJ, was that, quote, all of Mr. Kerr's problems with the shower posse originated and occurred in the United States, and while Mr. Kerr still feared gang reprisals in this country, there was little to indicate that he would face such risks were he removed to Jamaica, end quote. As to the evidence of anti-LGBTQ dangers in Jamaica, the IJ was alarmed and troubled, but not enough to grant cat deferral. The BIA affirmed. Before the Fourth Circuit, Mr. Kerr, through pro bono counsel, argued that the IJ and the BIA erred in their aggregate torture analysis. An argument that always has legs. But the Fourth Circuit did not agree. In the Fourth Circuit, as with most circuits, quote, an applicant need not establish that the probability of torture from any one source is over 50%. Instead, the question for the IJ is whether the cumulative probability of torture by all the entities, or for all reasons, exceeds 50%, end quote. But there is no specific methodology that IJs in the Fourth Circuit must follow, and to the Fourth, it was, quote, abundantly clear, end quote, that the IJ and BIA considered all torture sources cumulatively. To be honest, and at least as reflected in this decision, Mr. Kerr's biggest problem is that the IJ issued a thorough decision. The IJ did, for example, quote, consider the risk that the shower posse would target Mr. Kerr because of his sexual orientation, end quote. While the IJ could have been more thorough, the agency's analysis on this point was good enough, said the court. To the extent that the IJ focused primarily on reprisal killings from other gangs rather than the sexual identity risk, it was because Mr. Kerr himself focused on it below, and in any event, the sexual orientation risk was adequately addressed. Similarly, the IJ addressed Mr. Kerr's fears of harm as a criminal deportee. Now, quote, if, for instance, an IJ has intimated or it otherwise appears from the record that the likelihood of torture from each of several individual sources is close to 50%, but the IJ nevertheless puts the combined risk at less than 50%, then some further explanation may be necessary, end quote. But that's not what happened here. Here, the IJ held that all harms were well below 50% in and of themselves, allowing the Fourth Circuit to, quote, reasonably discern, end quote, the thinking behind the IJ's ultimate and aggregated risk determination. It is true, said the Fourth Circuit, that IJs in the Fourth might very well need to consider the compounding effect of harms. That is, if, say, LGBTQ former gang members are at greater risk of torture than are LGBTQ individuals or former gang members, even when combined, IJs can't just combine individual risks, but must consider the combined identity together compounded. And that makes sense, right? Jewish communists in the early years of Nazi Germany were probably at a greater risk of harm than were people who were only Jews or communists, even when combining those percentages together. The problem here, explained the Fourth Circuit, though, is that Mr. Kerr didn't make that argument before the IJ and the BIA. He presented no evidence that he'd be, quote, subjected to a risk of torture greater than the sum of its parts, end quote. The IJ and the BIA did what Mr. Kerr asked them to do below, so they could not have erred, petition for review counsel's very smart arguments notwithstanding. That means that Mr. Kerr must leave the United States after growing up in this country. And that is Kerr v. Garland. Moving on to Santos Garcia v. Garland, published by the First Circuit on April 28, 2023. 2 from the First Circuit on a Friday. So be it. This decision is about nexus. Mr. Santos is from Guatemala and, having been found to have a credible fear of persecution, was placed in removal proceedings to litigate his claim. He, of course, applied for asylum and related relief in immigration court. Deemed credible, Mr. Santos testified that he fled death threats in Guatemala. Specifically, quote, members of the Renewed Democratic Liberty, LIDER, party, threatened him on 3 occasions in March and April 2016, end quote. Mr. Santos believed that the threats were because of his support for the FCN political party. After the LIDER party was dissolved for improper conduct by Guatemala's Supreme Electoral Court, can you imagine that, U.S. voters? The party got violent, and men threatened to kill Mr. Santos if he didn't pay them money. He was responsible, they believed, as an FCN supporter and volunteer. He didn't pay, and in March 2016, a LIDER supporter dragged Mr. Santos into an alley, held him at gunpoint, demanded money, kicked and beat him, and left. Police refused his case because he didn't have proof, so Mr. Santos testified. During the third and final incident, a LIDER supporter, quote, drew a weapon and threatened to kill him if he ever contacted the police again or if he failed to comply with their money demand, end quote. As will become more important in a bit, Mr. Santos also testified, however, that, quote, LIDER party supporters targeted him because they had lost a lot of money because their political party lost, so they wanted to recover this lost money, end quote. Deeming asylum a, quote, very high burden, end quote, the IJ denied, believing Mr. Santos never suffered harm rising to past persecution and that in any event, his experience wasn't for the right reason under asylum law. It was just because the LIDER supporters wanted money. Mr. Santos was, after all, quote, able to walk away from each encounter unharmed and did not require medical treatment, end quote. Plus, the FCN party was actually the political party in power during all of this. The BIA agreed. And in this decision, the First Circuit affirmed the agency for a few reasons. First, it refused to consider Mr. Santos' claim that he suffered past persecution and feared persecution based on his, quote, membership as an indigenous Guatemalan male of Mam descent, end quote. Although he mentioned this argument below, he never testified to his fears or experiences on this basis at all, and the IJ and BIA made no findings. Perhaps more importantly, Mr. Santos never brought the challenge to the BIA, so he can't bring it to the First Circuit, said the court. Turning then to what the BIA affirmed, the First Circuit saw no error. True, in the First Circuit, quote, credible verbal death threats can amount to persecution if they are so menacing as to cause significant actual suffering or harm, end quote. But here, the First Circuit doesn't see the threats as credible. Instead, the court appears to believe that it was more of a bluff, quote, intended to frighten him into paying, end quote. The First Circuit supported this finding by the, quote, lack of severity of the one assault, end quote, and besides, reasoned the court, Mr. Santos never testified about how these threats impacted him or what he thought about them. Fine line, these death threat past persecution cases. The fact that the FCN won elections and that the LIDER party appears not to be in power or even a thing anymore in Guatemala didn't help either. At base, the court believes that the IJ and the BIA conducted the right analysis and that their findings were not wrong enough to overturn. So the First Circuit affirmed the removal order. And that is Santos Garcia v. Garland. The final case. Also from the First Circuit, Sharma v. Garland, also published on April 28, 2023. This case is about citizenship. Mr. Sharma claims that he is one. Now, he was born in India in 1979 to Indian parents, but as a young child, his mother moved to the United States and became an LPR. In 1990, when Mr. Sharma was about 11, Mr. Sharma's father passed away, and so he came to the U.S. to live with his mother. It appears, however, that somehow he did so without authorization. His mother then naturalized in 1995 when Mr. Sharma was 15 or 16 years old, and a few months after that, his mother filed an application for Mr. Sharma to adjust to LPR status. You could do that before IRIRA in 1995, even if he entered unlawfully. But by that time, Mr. Sharma had a juvenile criminal record, and apparently the former INS officer told him that he couldn't adjust because of it, or at least not yet, whatever that means, and that he needed to come back and have another interview. It went downhill very quickly from there. With his application pending in 1996, Mr. Sharma, quote, was involved in a shooting at a restaurant that resulted in the death of a bystander, end quote, and he was eventually convicted of second-degree murder and sentenced to life in prison by a Massachusetts state court. For immigration purposes, none of that would matter if he had entered the U.S. as an LPR with his mother way back when and then naturalized with her. But he did not. And apparently he's been released from criminal custody now. He got parole after 20 years. DHS wants to deport him. Can't do that if he's actually a U.S. citizen. But he's not, said the First Circuit. As an initial matter, the 1996 adjustment of status application was eventually denied by former INS for lack of prosecution. By that time, of course, Mr. Sharma had some pretty serious matters to attend to. But none of that matters if Mr. Sharma automatically became a citizen when his mom naturalized in 1995. That analysis requires application of the law in effect at the time, former INA Section 321A. There were many conditions required to derive citizenship back then, but this case turns on the fifth requirement. At the time when the parent's naturalization goes down, the child must be, quote, residing in the United States pursuant to a lawful admission for permanent residence, end quote. Or thereafter, quote, begins to reside permanently in the United States while under the age of 18 years, end quote. I smell a gong coming. Indeed, in matter of Nwozuzu, published by the BIA in 2008, the BIA held that this provision, quote, requires the non-citizen child to acquire lawful permanent residence status, end quote. Mr. Sharma obviously never did that, we all agree. But in contrast, the Second Circuit held that actually all that's required is a, quote, objective manifestation of intent to reside permanently in the United States, end quote. Then the Ninth Circuit held similarly in Chanu v. Garland, en banc no less, episode 55. And by the way, the Second Circuit's case is the BIA's Nwozuzu case on petition for review, which I would assume then makes the BIA's Nwozuzu decision immigration review zombie precedent, because I would assume that the Second Circuit must have vacated the BIA's decision. Just saying. But it doesn't really matter, because all of these decisions seem to come down to a textual analysis of the former naturalization statute, to which the BIA is owed no deference. What will the First Circuit say? Will it require actual LPR status like the BIA does, or will it permit a more malleable interpretation of an intent to reside permanently like the Second and the Ninth Circuits require? Gah, First Circuit! The court punted, as it did on the same issue in 2016. I need gongs, First Circuit. I need gongs. But no gong will be coming. Because even under the lower standard employed by the Second Circuit and the Ninth Circuit, the First Circuit held here that Mr. Sharma didn't meet it. Quote, subsequent events can shed light on how reliably the relevant metric demonstrates an individual's intent, end quote. In this case, the First Circuit didn't believe Mr. Sharma objectively manifested an intent to reside in the U.S. permanently because he failed to show up for that second adjustment of status interview despite being told to do so by a former INS employee at the time. Looks like he actually could have showed up because he didn't get taken into custody for the shooting until a bit later. Plus, he commits that shooting. And to the First Circuit, 16-year-old Mr. Sharma, quote, should therefore have known at the time of the shooting that committing a serious crime would further imperil his immigration status, end quote. All of this together showed the court that Mr. Sharma, quote, lacked commitment to his application process, end quote, and therefore that he lacked an objective manifestation to remain in the United States permanently. And because he never demonstrated that objective manifestation before turning 18, he can't benefit from his mother's naturalization, said the court. Complicated week. And you came so close to making some good law, Harvard Crimmigration Clinic law students. Excellent effort. And that is Sharma v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.